Great. Hello, everybody, and welcome to the last webinar in this legal tech series. I would like to introduce Victoria Thompson, who will be our wonderful moderator for this panel, IP, Law and Tech. So if I can hand over to you now, Victoria, thank you.
Thanks, Jasmine. Hello, everybody. Welcome to today's session. Today, I'm joined by a fantastic panel who have amazing experience in the space of intellectual property law and innovation and the impact that emerging technologies such as the Internet of Things, AI, blockchain and DLT are having in this practice area for their practice and for their clients. So today I'm joined by Anne Rose, who is the co-lead of Mishcon de Reya's blockchain group, an associate commercial technology counsel at their data protection, IP and sport practice. I've got Paul Craus, head of the FinTech, Blockchain and Emerging Tech at PwC Legal Middle East, specializing in AI, machine learning and policy and regulatory development in the Middle East. I've also got Raka Ray, Senior Associate at Galdani Advocates and Legal Consultants, specializing in IP, data privacy and litigation, again based out in the Middle East. And I have Priya Nigalpa, Simmons & Simmons, IP Group and Partner, specializing in IP litigation, patent disputes and trademark litigation, and leads their fantastic group that they have on emerging technology. So what we'd like to talk about today in the panel is how all of this amazing emerging technology is impacting the way our intellectual property laws and systems and treaties work, and how that emerging technology is also going to impact the practice of law in that area. And so without further ado, I'd like to hand over to Raka Ray to introduce an overview and provide us with an overview of that emerging technologies with a focus on what is AI. Everybody talks about AI, but what really is it? Is it this magical, mystical thing? So how that's impacting the practice that she has out in the Middle East. So over to you, Raka.
Well, thank you so much, Victoria. Thanks to the organizers for bringing across such a wonderful panel and a very interesting topic, I must say. So, like you mentioned, well, I'm going to just touch upon the general basic idea of exactly what is emerging technologies and touch upon a few major, I would say, the mothers of emerging technologies, because there's n number of emerging technologies now floating around in the space of innovation. Well, in terms of emerging technologies, is basically a technology which is new, or perhaps a technology which is currently existing but can continue developing more, is what we typically look at when we very simply would want to define emerging technology. But the most significant part of that is that it is a technology which definitely is expected to create a significant impact on the social and the economic setup of any country. That is definitely something which we really need to remember, because that is definitely the kind of technologies that we're looking at. So to kind of elaborate a little on few of the major technologies which is kind of I would say taking the maximum space of emerging tech is obviously the Internet of Things, or IoT. Well, again, very simple terms, it's simply, I would say, IoT is about extending the power of internet beyond computers and smartphones to almost the whole process of every other thing and environments. A simple example being, let's take the example of smartphones, where we would want to hear or listen to a song in the world. Well, that doesn't mean that we have to have the storage of every song in the world in our phone. All that we need to do is that this song is surely stored somewhere in the world, and it is this technology which allows us to send an information asking for the song and then receiving it through streaming. So this is in very simple way an example of what IoT can and has been doing for us, literally bridging the gap between virtual and physical worlds and making maybe life more smarter and comfortable for us. The other technology which we definitely cannot miss but kind of touch base on is about DLT, or the distributed ledger technology, which is systematic recording of transactions on a very decentralized manner, and at the same time making sure that everything is kind of recorded in a very systematic way. Blockchain being a very typical example of it. I'm sure we have a fantastic panel who's going to touch upon more onto the intrinsic issues regarding blockchains. Again, I would say the primary topic of emerging tech is AI, or artificial intelligence. And like Victoria mentioned, that what exactly is AI? Well, I would say AI used to be in the past, in the times when we were in law school, perhaps, that it was just a part of the science fiction movies, where we've seen robots definitely taking up on control of the world. Well, I believe it's no longer a movie, it's here, and it's definitely here to stay. So it's definitely something where intelligence demonstrated by machine, or machine intelligence, is what we would term AI as. It's, in very simple terms, it's a stimulation of human intelligence, which is getting programmed into the thinking of machines, so that they start thinking and mimicking like humans. Typical examples being self-driven cars, machine playing chess, disease mapping apps. Welcome to the world of Corona. We've seen this app being extensively used right now. Robots, of course. In terms of an impact, like as Victoria mentioned, an impact of AI primarily into the space of intellectual property. Well, I, as a practitioner on IP, I have seen there has been already an enormous technological and social consequence, which has already impacted this space. This topic is actually very broad, and I can actually spend hours, given my passion towards this, continue speaking. Being mindful of the time, I'm going to just touch upon its impact on, typically on patents, on trademarks, copyrights. Well, typically, if I am to look at patents, the first question that comes to my mind in terms of the impact of AI on the space of patent law is on the issue of inventorship and ownership rights. Questions like whether an AI application be made as the inventor, does it really require a human who should be the inventor, or if it is a human who should be an inventor, irrespective of an AI being involved, what are the indications which is really required for the law to be permitting this? Well, in our past experience, we have seen typically two cases, where in the first case, it is the AI getting operated by a human. So obviously, in that case, we've definitely traced it back to the inventorship going to a human. Whereas in the second case, it has been typically identified as an invention which was squarely done by the AI's intervention. And yes, it was definitely the inventorship goes to the AI. When in such cases, I would say the most important impact with patent law would have to see is to trace down and identify the source of invention. Unless that is there, it is not possible to really come across the question and answer it, that who exactly is the inventor, because somewhere the lines definitely do get blurred. In terms of copyright, well, I would say as of now, copyright is still traditionally expected to be a law where a human intervention is mandatory. So be it the law of the world, be it from Spain to Germany to US, everywhere, typically the definition of copyright expects that the author has to be a human. Well, having said that, under that circumstance, the question of an AI being given the right of copyright is fundamentally not there. The way I look at it is there can be two treatments which copyright would do in case of an AI intervention. Is either they completely reject copyright being given to any creation which has been done artistically but by an AI, or they trace it down to the author of the program, and then it is attributed to the author. The other aspect which I just wanted to touch upon is on trademarks. Well, we've seen already in terms of a concept of curated offering that trademarks definitely exist in terms of the way the brand owners would be looking at the algorithms in terms of the choice of a retailer's brand, and that getting circulated every time that you would want to buy something. The same thing happens when in choice of films and movies, where Netflix typically follows the same strategy as well. However, when it comes to the legal part of it, as a trademark lawyer, it makes me think that there are two basic fundamental bases on the basis of which brand is selected by consumers. One is the assessment of the brand information, and the second is the purchasing decision. With an AI intervention and with an AI assistant really choosing brands, I literally see none of these impacts actually working out. They both literally not being there, because typically it could be the AI getting programmed and choosing a brand irrespective of these decision-making factors. The other obvious aspect is the basis of a trademark violation, where human senses and thoughts are of major importance, and imperfect recollection, consumer deception, confusion are the basic fundamentals of trademark violation. What makes me think is that will an AI assistant have imperfect recollection? It usually is expected to be having perfect memory, right? So, or would it be, kind of having a perfect pronunciation, or would the brand owners will provide a perfect pronunciation which would be used by the AI assistant, or will there be even a discrimination that the AI assistant would be applying to even see the difference between a product or a brand which is worth pennies and a brand which is worth thousands? Because these are the fundamental aspects which decides on a brand violation. So just to reiterate the words of English IP judge who once mentioned that unless an AI assistant is a moron in a hurry who's purchasing products in terms of complete deception, well, it's a matter of time for us to see whether this is really going to be a case, or whether IP laws would completely go a major change to adapt to these aspects. So yeah, I believe I'm going to be ending at this, Victoria, and I'm happy to answer any questions which comes along or contribute later. Thank you.
Many thanks, Raka. That's really interesting overview. And I think it's going to be interesting to see how more and more of these tools come into practice and then they impact people's decisions making. I know from my time when I was working out in Asia and up until recently, up at that point when I was head of intellectual property practice for Development Bank of Singapore, prior to the New Balance case, DBS had the record for being one of the only non-Chinese institutions to actually get a damages claim in for trademark infringement. And then where sort of IP practice is going and the courts are going in China, looking at how AI might be used in that space is going to be really interesting. But with that in mind, I'd now like to turn to Priya, and she's going to be giving us a little bit of an overview of what it means to protect AI inventions. And if you're an AI inventor, what does that mean? And Raka touched on that a little bit about how you really manage this technology protection from a confidential information perspective, to where do you go when you're securing patents on these types of things, and how best to navigate that minefield. Because I know, as a person who is helping people try and get patents when I was either inside Barclays or inside Development Bank of Singapore, or even back in private practice, it was an overwhelming process sometimes. They felt quite intimidated when they first came in with their initial disclosure form, to then all the way 3 years later when I sent them that nice email saying, yes, we've survived and we've got a grant. So with that in mind, hopefully Priya's got us some hope that this might get to be a bit better and not as difficult in the future.
Completely. Thanks very much, Victoria. So I think where I wanted to start really was to look at IP protection for AI. And Raka's touched a little bit about what happens when AI starts to create IP. So I'll start with the IP protection for AI technology. And as Victoria said, patents are often the starting point. I think in part because WIPO did a comprehensive study last year where they looked at patent applications that were being filed for AI-related inventions. And they certainly found that there was a surge in the number of patent applications for AI-related inventions, unsurprisingly, given that it's an area of emerging technology that is, forecast to have such a huge impact on so many aspects of our lives at the moment. And what WIPO found was that they identified 3 growth areas when it came to AI patent applications. The first was applications for robotics. And they suggested that there'd been a 265% growth in this area since 2016. And that's only in the last 4 years, which is really quite impressive. And as well as robotics, they also identified that control method patent applications had also increased. And so these are the sorts of applications that would typically manage the behavior of, for example, things like robotic arms. And the third area they identified was computer vision, which is the category that typically image recognition would fall into. So again, unsurprisingly, given how much we're seeing about the application of AI to image and text recognition, WIPO identified that there were a number of patents in this space. So despite the fact that we're seeing an increase in the number of patent applications in this area, it can be challenging to secure patents in this space because there are certain exclusions from patentability which are relevant in the context of AI. So first of all, abstract discoveries and ideas can't be patented. So if someone has a brilliant concept, unless it has a technical application, it's going to be difficult to secure a patent for that. Computer programs as well per se can't be patented unless they achieve a technical effect or solve a technical problem. And in the context of AI and machine learning in particular, the European Patent Office considers AI and machine learning to be mathematical models. And patents for mathematical models, again, can only be granted if they identify a specific technical purpose or application for the AI algorithm, or a specific technical implementation. So the technical implementation relates to when the AI algorithm accounts for some kind of limitation on the hardware on which it runs. And so it's generally quite narrow. And so typically in this space, what we're seeing is that in order to secure a patent for an AI-related invention, you need to be quite particular about the specific technical purpose or the application for your AI algorithm, so that it's not an application for an AI algorithm in a vacuum. And the sorts of applications that are succeeding in this space are algorithms for speech or image recognition. So again, quite specific application, or otherwise, for example, the use of neural networks used in the context of digital health products. So for example, a heart monitoring apparatus to identify irregular heartbeats. So it's the hope, there is hope. It's not all lost. You can secure a patent in this space. I think the other reason why patents are sort of questioned when it comes to emerging technology is because of the difficulties associated with enforcing them. So when you have a patent for an AI-related invention, if a rival AI model runs on a cloud server and it's difficult to explain how it works, how do you prove that your patent has been infringed? In this context, from a regulatory perspective, we're seeing the regulators insisting on explainability statements. And those sorts of statements might be very helpful in a patent infringement context if they explain how the AI model works. And I think there's an open question about whether in this space, infringement cases will need to be brought on the basis that an AI model responds a particular way to an input and delivers a particular output. But the question is that going to be enough to prove infringement of a patent? And that's going to depend very much on the patent claims and precisely how the patent's been drafted. So I think when it comes to protecting AI technology, people start with patents, but it can be challenging to secure a patent in this space. And then you have issues associated with enforcement. And as a result, what we're seeing is a lot of companies having to think beyond patents and think about an entire suite of IP protection. And so they need to look at the other rights. And I know from conversations with IBM that at the moment they're actually considering relying on trade secret protection because they don't want to disclose details of their AI models and their algorithms in a patent application. They'd actually like to leave some of that outside of the public domain. And so then that becomes an interesting debate about whether, well, how much information do you need to put in your patent application? And should we be sharing this information because it's for the greater good and the development of technology and innovation, which I think is an interesting debate in its own right, which we could have separately. I mean, if you're looking at trade secret protection, ultimately, confidential information and trade secret protection applies where the information is proprietary and it has the necessary quality of confidence. And recently, as a result of the Trade Secrets Directive, if you are looking to protect something as a trade secret, you need to be able to demonstrate that you have taken reasonable steps to keep the information secret. And so this is a sort of a new threshold that we've seen introduced in English law and in countries around Europe, that actually there's an onus on the trade secret holder to demonstrate that it's taken steps to protect its information. And in the context of AI, we'd expect the details of the algorithm to be confidential if it hasn't been explained to the public in an explainability statement. And you'd expect at least the parameters and the weightings in an AI model to be confidential as well. So definitely worth relying on confidential information and trade secret protection. And then lastly, I think the other two rights that are important in this context are copyright and database rights. So most people are aware of copyright subsisting in films and music and text, but copyright also extends to computer programs when they are expressed in source code or object code. But the issue with copyright is that it doesn't protect functionality or the underlying idea. It only protects the idea once it's been sufficiently worked out and expressed in code. And the difficulty then arises where you have two programs that achieve the same result, but the code base for each of them is very different. In that context, you're looking at non-literal copying of source code, which is still actionable, but it can just be very difficult. And it means that you have to wade through thousands and thousands of source code files, looking for examples of copying, which can be tricky. So that's what I was going to say about copyright. And then on database right, Raka mentioned Internet of Things, which is underpinned by big data. In the context of AI, the training data sets are incredibly important because they impact the robustness of the AI model. And in that context, in Europe, we have a right called database right, which protects the investment that's made in collating and creating a database. And so in the context of the training data, I think database right is going to be quite important as well. So I mean, that's a bit of an overview of the different IP rights that apply in the context of AI specifically. I think, some of those principles are equally applicable to other areas of emerging technology because these technologies are so new, because they're so disruptive, because the IP system is catching up to protect some of this technology. It does mean that businesses need to be quite creative about their IP strategy and look at a number of different rights to protect their innovations. Raka has already touched on what happens when AI starts to create IP, and as she said, That's a bit of a hot topic at the moment. In the context of patents, the question is, can you have a non-human inventor? And the UK Patent Office, the European Patent Office, and even the US Patent Office have all said, no, you need a human inventor. So we're not having machines having patents. So we've got an answer on that one. But certainly in the UK, the case is appealed at the moment, has been appealed, it's under appeal. So we expect to see some more development in that area. And then in the context of copyright, the issue is that most copyright systems are underpinned by the central concept of having a human author. And so what happens when you don't have a human author? Should an AI own a copyright work? And so before I hand over to the next speaker, I just wanted to touch a little bit on applications of AI in litigation. From an English law perspective, I think where we are seeing AI and machine learning being applied the most is in the context of document review. As most litigators will be aware, businesses generate vast amounts of data. And so in the context of disclosure, there can often be a number of different sources of information, all of which needs to be collated, searched, reviewed. And certainly, the courts are encouraging the use of technology to review those documents. And there's an onus on parties to think about that early. But in the context of AI, we've moved away from predictive coding, where lawyers look at a subset of documents, which the predictive coding algorithm then uses to predict the relevance of the remaining documents. And we've moved to continuous active learning, where actually you have AI algorithms that are predicting the relevance of a document just by observing the decisions made by a human reviewer. So I could log onto the system and start reviewing a series of documents, and the AI algorithm in the background will learn from the decisions I'm making and predict the relevance of an entire data set, which can vastly cut down the number of documents that need to be reviewed, and can lead to great cost savings, which is obviously really important in the context of big commercial and IP disputes. And Victoria, you touched a little bit on AI judges. I thought it was quite interesting that in the UK, we're sort of using AI and machine learning to review documents. It's all very predictable, as predictable as you can be in the context of AI, and it's all very careful and it's appropriate safeguards in place. And in China, they have AI judges. So they have chatbots in Beijing who answer case management questions. But what I was particularly impressed by were the virtual judges in the Hangzhou internet court, which are more sophisticated than chatbots. They actually sort of run alongside real judges, and using machine learning technology, they preside over hearings, they understand and respond to the parties, they summarize key dispute issues. I mean, it's really quite impressive. I think there are safeguards in place, and that the human judge can intervene if the AI gets it horribly wrong. But certainly, it's quite interesting to see that that's where the technology is going in a legal and litigation context.
Well, I think given the volume of litigation and disputes and claims that are required in a jurisdiction like China, and just to purely deal with the language barriers that you have from district to district, has been a great help to people out there being able to access the system and the times at which people can be heard. But hopefully the right appropriate safeguards will be put in place around that as it develops and steps forward. But thank you very much for that overview. I do hope that it makes people feel like the IP system is more accessible as this develops, and that technology can enable people to access the IP system, because fundamentally the thing that made me be an IP lawyer was ultimately this is part of a social contract. You contribute to inventive and creative development in society, and in exchange of that you get these bundle of rights. So hopefully we can encourage that, and whilst the system, it becomes difficult to protect inventive emerging technology like AI because of the way the original IP system was created, because this wasn't a concept they were thinking about. I hope that doesn't mean then we revert to secretive trade secret practices, and that we still manage to maintain that thread of social contract around innovation and creativity. So with all of that in mind, I now turn to Paul, who's going to talk to us about what the work that he's been doing in IP policy and emerging technology through his team in the Middle East, because it's a trend that we've seen, I would say, in the last decade, really, of emerging countries leveraging IP diplomacy, the IP judicial system, and alluring people to come and set up their inventive companies in their jurisdictions because of their IP policies. And I think that's something that the Middle East has seen and leveraged from Japan and Singapore and other countries like that. And so without further ado, I'll hand over to Paul. Thanks, Paul.
Great. Thank you very much, Victoria, and hi, everybody. I'm so happy to be here, to be talking about AI and what's happening in this space. So I'm going to try to look at this from a slightly different angle, based on the work we've been doing with a number of regulators and governments here in the Middle East. But I want to start with one point, which is super hot now in the AI space, which is around bias and ethics. And this is one point where we're seeing engineers, data scientists, and lawyers sitting all together and trying to figure out how to fix this issue around bias, for example. And so bias in a nutshell, when you have these algorithms, you have prejudice for or against something or somebody. And so, for example, easy example, if you are a man and you're searching, you're using the Google search engine, chances are you're going to get ads like how to become a millionaire. While as if you are a woman and you're using the Google search engine, chances are you're going to get ads like how to lose weight. And the question is that this is obviously there's bias in the algorithm. But the most important question is that where is this bias coming from? Is it from the real data? Is this real life? As many people and many data scientists obviously claim, this is the real data. We use real data, or is it the algorithm in itself that discriminate or has elements of bias? And obviously the answer is not super easy. Probably another example here, Amazon, for example, they've developed a very nice hiring platform. It's all machine learning. And the platform, basically what they did is that they've collected resumes for a period of 10 years. So this is all the applicants that applied to Amazon for a period of 10 years. And the majority of these applicants were male. And the majority of these applicants, they used, for example, in their resumes, words like captured, executed. So these are like more masculine words. For example, we lawyers sometimes use these words. Executed a deal of $1 billion. Captured this and that. So they ended up having an algorithm where basically discriminated against women, and so it was biased, for men. And obviously, Amazon had to relook into this, and they're now working on redeveloping their hiring algorithm. But the real issue here is that we know that in reality there are biases. So human beings have their own biases, and the issue is that how do we fix this bias? Is this a purely technical issue? Is this something we can fix? The engineers, the data scientists, Google, Amazon, Facebook can fix, or this is something that you need lawyers, you need third parties, overseeing what's happening in this space, and maybe coming up with different approaches, maybe the different strategies on how to solve this. And so this is where I personally, myself and my team have been involved in looking at a number of cases here in the Middle East about. The Middle East is quite unique in the sense, in the UAE, for example, we're the only country which has a ministry for AI. So it's the first ministry and first minister for AI. And we're going to talk in a bit how governments now are competing when it comes to AI, and how this is going to create opportunities for lawyers, especially for graduate students. It's a completely different, new different field. And so the idea when you're looking at bias and ethics in particular, you want to have a multidisciplinary approach, and you want to get everybody on the table. But most importantly, you want to have somebody who can audit these algorithms, these machine learning systems, and to ensure that the data fields, that the systems, they represent all groups of societies. They represent all genders. They represent all the wide society basically representation. And so this is something obviously very difficult. Sometimes it's usually it's easier said, but very difficult to apply. And so when it comes to bias and ethics, what one of the countries, for example, here in the Middle East, they're doing at the moment is that they are coming up with a code of ethics. And the reason is that, yes, we trust big tech companies, but obviously to a certain extent. So governments are trying to step in, whether directly or indirectly. Now, directly by sometimes putting, code of ethics, and where basically they are requiring these tech companies to comply with, certain ethics guidelines against, for example, discrimination, bias, and could be, for example, one of the requirements we've seen in one of the states in the US, where the state legislator basically they require now tech companies to be audited by special third-party companies who will audit these algorithms before these algorithms go live. And obviously, this is a big impact on tech companies. On the other side, we've seen obviously some of the big tech companies lobbying for self-regulation and having having their own codes and ethics and and guidelines. Now, the importance of this is that when I look at AI, I look at basically, and in my personal opinion, I think it's going to be only a very small number of companies that will be able to do AI. And the reason is very easy. In order to have an AI system, you need big data. And we're talking here about massive amount of data, massive computing power. So to me, it's going to be basically, a small number in the, of tech companies in the US, and a small number of tech companies in China who have access to massive data. So, think Amazon, Google, Apple, Microsoft, think Alibaba, Baidu in China. Again, there are questions of how they're collecting data, personal data. But we're not going to discuss this, today. We'll leave this until later. But the big question here is that, what can then small companies do in the middle of this? If we're saying that big tech companies who have access to tons and tons of data are the ones who are able to come up with these AI systems. Now we know that small companies can come up with AI applications, which may be different obviously than systems, but at least they can create these applications on top of the AI systems or on top of certain AI systems. And so the key thing here is that what we've been seeing lately is that small governments, or I should say small countries like the UAE, Singapore, Estonia, they're trying to capitalize on AI. For example, one of the key things they're looking at now here in the UAE, they're expecting that AI will contribute something around 12.6% of the GDP in 2030. This is a big number. And so the idea, in order to have, in order to attract companies, these small companies who build AI applications, obviously you need a regulatory framework. And so you need, for example, regulations like digital ID, digital signature. You will need, for example, to understand who will be liable if something goes wrong. For example, if in a self-driving car scenario, right? Is it the manufacturer? Is it the the owner of the car? Is it the insurance company? So there are serious questions that are undecided yet, and will have, I think, serious implications, whether on us as lawyers, on graduate students, on scholars, on data scientists, and basically on everybody. And also there will be also the necessity of having code of ethics, and who will basically have oversight of these code of ethics. Who will ensure that these big tech companies and also small tech companies who are using AI, who are developing AI systems and AI applications, will be able, will comply with these ethics. I'm gonna leave it. I'm gonna stop at this. But if anybody has any question in particular about AI, our work in AI, I'm more than happy to take it afterwards.
Thanks, Paul. It's fascinating to see how this is developing. And I think an interesting trend that I'm seeing as alongside these national moves to attract companies who are developing and emerging technology business models is also creating open data reference frameworks. So to compete with these huge companies that have sources of data from their existing business models, like you mentioned, the Googles and the Facebooks of the world, how do you create an open data economy? so that you can then attract these emerging businesses. So the likes of Japan have their innovation hubs, and they've took specific steps to put legislation in place to create open source medical data for reference and for open referencing, which has been a great success for them. Again, you have seen the likes of Fujitsu and the traditional medical companies have much more success with that, but it's also about creating that balance and competition. And so I think that's another area that will become of increasing significance alongside IP law, data law. You will look at actually competition law and how it looks at using data as a yardstick for actually your analysis of dominance. I think that's going to be something that we see even more. But over now to Anne, who's patiently waited there to talk to us all about IP and DLT, one of my favorite subjects. As a founder of the London Blockchain Foundation and somebody who's been messing around with the smart contract space for longer than I should really admit on a recorded forum, then I think it's really interesting to have Anne talk about how DLT is going to play into this convergence of emerging tech, of the Internet of Things, DLT, smart contracts, and AI, and how that will all mash together to make some cool products that we all want to enjoy and get our hands on. And so, and then other themes that can stem from this is about actually then how can registries and practices develop and leverage this technology so we can start to finally get some real-time data on who owns what and who's doing what. Because right now, practitioners in this space, it's a little bit like maybe 12 months, 18 months. We're not quite sure how good our sources of data are. So thanks, Anne, and over to you.
Brilliant. Yeah, thanks so much, Victoria. Yeah, I really think I'm a massive advocate of blockchain in the IP sector. I really think it could transform how the industry works. And, you know, if we're going to take, say, registration, it can make the registration of a design right or a trademark so much more efficient by cutting down on some of the current processes and procedures. As you noted, like, you know, when is it going to register? And for some trademark applications, for example, as well, where it's not possible to show that the trademark is inherently distinctive, it will be necessary to demonstrate, for instance, that the mark has acquired, you know, distinctiveness perhaps through use. And assuming we made changes in the law to actually allow for actual use of a trademark to be added to and recorded on an official register, you know, evidence and information of actual use of a trademark in trade, as well as the frequency of such use, could be easily shared and available for everyone to see. And it'd be fantastic, you know, if trademark owners decided to make all this information freely available, because it would just save huge amounts of time and cost. And I think as well, one of the things that would really help with this is, as you touched on as well, you know, smart contracts. And to put it simply for people, you know, this is in very simple terms, it's a self-executing computing code that automatically processes its inputs when triggered. And using them could actually provide evidence of a timestamp of first or subsequent use of a trademark, which could then be presented by courts and evidence. And both Priya and Victoria mentioned, you know, all the courts in China and these newly developed internet courts, which allow, among other things, for evidence which is stored and verified in blockchain platforms to be used in legal disputes, which I think is incredibly exciting. You know, and last year you were talking about, Priya, you know, in Hangzhou with the virtual judges, and actually, you know, there was this case with there was like blockchain-based evidence in an online copyright infringement case, which was, I think, is just so exciting and really transforming the way in which this industry could go. I mean, in Europe, we've got the European, the electronic identification and trust services regulation, and already as well, that's starting to include provisions that prohibit courts from denying the legal admissibility of timestamps as evidence on the sole grounds that the timestamp doesn't meet, you know, the technical requirements of an EU qualified timestamp. And you know, and I think that is great, and I think that we're moving slowly in the right direction. So I touched briefly on smart contracts earlier, and so as well as registration, you know, I really think it could transform licensing of IP. and allow the transmission of payments in real time to IP owners. And this is something which I think is incredibly exciting. And this information could include rights management information like ownership, use permissions, payment terms. I mean anything. And I feel at the moment it's starting to become mainstream. We've got commercial providers, startups, non-profit organizations, like, I don't know if many of you are following the Accord project, but it's building open source code and documentation to maintain this common and consistent legal and technical foundation for contract management, which I think is very exciting. And it has all the software that's needed to author, edit, and execute smart legal contracts in a standardized way. So I think, whilst we can't say necessarily right at the moment that smart contracts are the future of digital rights management, I think you can safely say it could redefine how creators are remunerated. Often instantly via micropayments, by acting as this platform for creators and distributors of IP, particularly as I think some of the changes that have to happen have to be maybe more at an economic or social level, less issues with the technology itself. And I think as we're starting to get on with more global standards coming out and people providing more guidance, which we're getting from local governments and authorities, I think it makes it a safer place for people to start entering into and feel that they can go down this route. I think one of the things that still very much seems to be up in the air is people finding reliable oracles, which are agents who retrieve and verify real world occurrences and then submit that information in order for smart contracts to self-execute. And I think one of the other things as well, which I find very interesting as well in the IP space, is using this technology along with other things to be able to transform, say, anti-counterfeiting and looking at enforcement and traceability for IP owners. So, you could add scannable blockchain connected tags or engravings to your products, which include legal and other information which can enhance the effectiveness of customs enforcement in the fight against counterfeits, and also assist when it comes to validating a genuine product by customs authorities. So although at the moment it's possible to record trademarks, patents and designs with customs authorities and request that they detain and destroy any infringing products, it's quite difficult for customs authorities at the moment to ascertain whether those products are actually infringing. So if you have an IP rights owner is able to inform the customs authorities whether these products are indeed infringing, and that it's the genuine product is embedded with this tag or this engraving, then the absence of that tag bearing the incorrect data is an easy way for customs authorities to check whether that product is counterfeit. And it would also, I think, really help customers regarding and understanding about the dangers of fake goods. And in the luxury market, I think this could really transform that space, especially for things like handbags, where you can easily, put on, and embed the codes, which is then based on a blockchain platform, rather than say using things like clothes or something that's which is going to be washable, and you put it in, and it's just seeing whether there's technology at the moment for allowing that to happen in that space where you can actually start washing your products and still start using these tags. And while things like QR codes, aren't new, what's interesting about a blockchain-based solution is that it doesn't suffer from the drawback of where you're having copying the QR codes and making it prone to corruption. So you're unable to alter that information that's on the platform. And the ability to add blocks of data to the chain can also create opportunities for IP rights owners to record details on a product's process as it goes through stages in manufacturing and supply chains. So trademark owners, for example, could use the function to record where goods are placed in the market, which allow them to distinguish grey goods in cases of parallel imports, and to identify where they left their supply chain. So, and in the same way, blockchain could be used to monitor and control leaks from selected distribution networks, and so assist enforcing those agreements. bearing in mind, obviously, as you mentioned about Victoria, competition law considerations. And I think this space is so exciting, and I think there's so much happening here at the moment, and I'm really interested to see how it develops. And one of the things I've been doing with Tech London Advocates, which is a group I lead, the Legal Regulatory Blockchain Group, is looking as well at some of these IP issues and seeking guidance as well from certain authorities in terms of looking at interpretation of legislation with this really exciting new platform.
Many thanks, Anne. That's really exciting.
I think it's exciting.
I mean, for somebody who has been sort of playing around in this space and working with companies that are building solutions, I mean, the likes of Bernstein Tech in Germany, you've got IP Vault out there giving simple, accessible solutions to enable people to protect and hash their designs and ideas. Or you've got Pixie and things that they've been doing as well. It's really an emerging space, and it's great to see today that you've got Providence by the European Commission getting £1 million worth of funding to look at actually tracking and tracing the origin of goods. So
I love that as well, and Providence is one of my clients, so yeah. I'm really excited. Really excited for them. They are just growing and going from strength to strength, and they're just such great clients to work with.
And when you think about from a tech for good perspective as well, the importance of actually thinking about our supply chains from a medical perspective. So there is a huge amount of counterfeiting in the drug space, and then making sure actually that the thing that arrives that's supposed to save someone's life is really that. And so there's huge work to be done in that space as well around counterfeits of drugs. So we look forward to seeing more on that. So with all of that in mind, I'd like to hand over to Rob now, who I didn't get to introduce, but Rob is a partner who heads up the CMS TMT Middle East team. And Rob's going to have a little talk now about how all of this comes together and impacts the future of practice as an IP lawyer and technology lawyer, and what do we need to be doing if we are thinking about this career and fast forwarding 10 years, where will we be? I will hopefully be on a beach if we're still allowed to go out and drink and sit on a beach, but where will the future lawyers be if they're into this space, and what will they be thinking about? So if you're ready, Rob, over to you.
Okay. Just firing my camera up.
While Rob's sorting his camera out, for the people and the attendees, if you want to start thinking about questions, once we finish this round of panels, we'll be opening up the Q&A, and you can put those into the system, so we can think about how we can test the panelists on their knowledge.
Right, so the camera's not happening, so you're just going to have to go with me blank, which is a shame. But anyway, so yeah, I mean, we've had some fantastic inputs from the panelists about some of the amazing technologies that are available. And I think it's probably one of the most interesting times to step into the legal field. And I feel very, very jealous of a lot of the junior lawyers coming through, because some of the things they're now getting to work with, particularly on the sort of the legal tools and the legal tech side of things, are truly fascinating. And for those of us on the panel and those of us listening, the dark old days of being sat in deal rooms or scanning through thousands of pages of IP documentation or whatever it may be to look for specific representations or trademark filings or patents or whatever, they seem to be in an end. And I think the future of the law firms, particularly sort of on the back of what's been happening with COVID and all of the remote working is that organizations now are looking a lot at automation, and the IP spaces and the tech space are the obvious sort of groundbreakers for that. And I think with respect to the success of law firms going forward, you know, automating workflows such as IP filing and taking away a lot of the basic work from paralegals increases productivity, increases our ability to charge our clients a much fairer fee and redistribute savings, and encourages a much greater volume of sort of IP work coming through our organizations, because it creates this sort of flywheel effect where you're charging less but providing a faster service purely because you're employing, you know, top quality legal tech and automation to IP registration processes, to patent applications, to patent searches. And you're moving your junior IP professionals away from sort of rote tasks, and eliminating the need for your top quality professionals in the organization to perform routine tasks. So what you will end up with is, you know, IP lawyers in the future becoming very specialized, and where a manual task is required, those individuals are very plugged in, are very unique at the way they can operate a whole host of different programs to provide a really fantastic and efficient service. And I think some of our panelists have already mentioned, you know, the exciting prospect of AI speeding up components. And we've seen, obviously, digital courtrooms. We've got a fantastic digital courtroom process being developed in the Dubai International Financial Center, which is engaging with blockchain to publish judgments that can then be enforced on shore. So yeah, the use of blockchain in judgments it's been had a phenomenal impact on the speeding up process. And of course, that then changes the way our litigators work. And all of a sudden, you know, people who were quite skeptical of blockchain and associated blockchain with things like cryptocurrencies and various schemes are now very aware of the power of blockchain in the court system to provide what our clients really want, which is, you know, a really fast, efficient, cost-effective service. So I think we have a really important role to play as lawyers in the future. And then I think another big change that's happening as a result of this tech, and this Zoom example, this Zoom call is really a great example of, is the virtualization of law firms. You know, a lot of our clients now work remotely a great deal of the time. We're all logged in remotely on this Zoom call. Everybody's now working from home. And certainly at CMS, what we've seen is the availability of legal tech tools has allowed sort of virtualization and remote working to actually be done really, really effectively, because we can plug into tools like Kira. We can plug into tools that use natural language processing for, you know, checking out and searching IP records. You know, the patent office is now fully online, even here across the UAE and Saudi. So we can search thousands of patents in a matter of minutes. We don't have to be in the office dredging through boxes. So, you know, what this all means is that you're going to see a lot less focus on giant law offices and face-to-face meetings, and a lot more focus, particularly in our space, on the ability to do what we're doing now, to log in remotely, to advise our clients via Zoom and via Teams, and to apply tools and undertake registrations for them, you know, virtually, using blockchain, using AI, using fantastic analytics, without the need for all of these face-to-face meetings, visits to patent offices, visits to trademark offices, and, you know, in the comfort of our own homes. And the cost savings for our clients and the efficiency savings for our client are going to be a huge part of this. Now, Victoria interestingly mentioned the sort of the data ownership concept and the issue around competition. And I think that's also going to play a very big role in the legal space as well, because I think there's going to be, you know, a schism that develops between those law firms that deploy legal tech quickly and efficiently, and obviously those with, you know, the greater volume of clients who are able to make really efficient cost savings on a huge range of things, not just IP registrations, but also smart contract development, use of blockchain for a range of legal issues such as, property completion, corporate M&A deals. We've seen it, for example, in a lot of our shipping law cases for verification of goods and services, date and time stamping goods to prevent counterfeiting. So it's going to be really interesting to see that whether the same gap opens up in the legal field. And I think you're going to have two sort of camps. Those firms that have a smaller pool of extremely well focused individuals who are experts in particular fields and who are able to focus on specific tasks in a really niche area in a virtual law firm, and the bigger law firms will be whittled down to those that use legal tech efficiently and therefore steal a march on their rivals in terms of the service, the speed, and the efficiency of cost that they're able to provide. So I think the law firm of the future, the law market of the future for clients, and particularly in our space, is going to be very, very different to what it is now. And I think one of the things that this crisis has done has possibly sped up the process towards law firms engaging tech, looking at virtualization of a lot of their departments, and looking at hiring individuals who have, a very specific expertise in an area of law. And I think IP is a really great illustration of, how tasks can be really automated and allow clients to get a top quality service at a much cheaper price than they were used to having. So that's really it from me. Happy to pass over to Victoria. I'm very sorry my video didn't work. We do Zoom in the UAE are not friends. They have been recently. But at least I've not been frozen out of this one, which has happened a few times when I've done webinars recently, which has been highly embarrassing. So at least you've got the voice, not the image. So I'm sorry about that, but I'll pass back to Victoria.
No worries, Rob. It's quite like an emerging tech thing. You're just a voice in the dark. It's quite cool. It's very futuristic.
I thought it was more 1950s sort of president on the radio style with everyone around the wireless listening, but there you go.
You've done far better than me. I had the joy of a similar thing when my Mac arrived the other week, and it refused to do anything in Microsoft Teams, and I ended up equally just being a very strange automated voice apparently to everybody else on the conference in the background. But there we go. I think it's fascinating, and I wholeheartedly agree. If you're going into law today and you're a student and you're thinking about, okay, so what seats am I going to do in my training contract? What modules am I going to take in my final year? I would be definitely picking IP again if I was back doing this all again a few years ago. Because I think more and more you will see the importance of actually having skill sets that stand you out as a human. As more things become automated, and as a passionate person in favor of striving towards utopia, where we're all only working 10 hours a week and all we focus on is what makes us distinctly human, and all we have to do is go into the office to press a button and then we go home and enjoy life. We can focus more on creative pursuits. And therefore, the things that will be important in the future is intellectual capital. And what are the laws that protect intellectual capital? It's intellectual property. So therefore, I think it's a great field to be in as we move forward into this industrial revolution of technology. So with that in mind, let's have a think about sort of the questions that we can test this panel with. So with all of this in mind, do we think then that we need better regulation? Do we need open licensing frameworks to avoid a repeat of that whole 90s mobile tech litigation explosion we had around sort of telco sector patents and things like that for emerging technologies? Is that something we need? Who wants to put their hand up for that question? Ooh, or am I going to have to pick on someone?
Yeah, hey, Victoria, Paul here. Happy to answer this. So the way I personally look at this is obviously, innovation moves, in a very fast pace. So unlike regulations, right? And given the amount of technology we have here, and then the nature of these emerging technologies, in particular blockchain, AI, and some of the other emerging technologies, we really need to be looking into new regulations. And I think number one, we really need to look at the purpose of regulation in the first place. So if you regulate, obviously the idea and the approach that I think majority of the countries have taken is that we only regulate where there is risk. If there is no risk, then let the market deal with it. We don't want to over regulate, because then the risk is that you may stifle innovation. But at the same time, the question is that how do you identify the risk when, for example, when it comes to these emerging technologies? So if you have, for example, a company as big as Google and Facebook, so they have risk controls, they have strong operating model, they have cybersecurity systems, they have data controls, strong governance, blah, blah, blah. But then when you look at a startup who is getting into AI, for example, or blockchain, now the question is that you want these startups because obviously, you want new ideas, you want new people getting into this space. But at the same time, how do you make sure that these small companies or startups have the same systems? And I think in first place, do we want these startups to have the same systems in place, same controls in place? Yes, we're concerned about data protection. We're concerned about personal data and sensitive data. But also at the same time, if we're going to end up requiring these small companies, in particular startups and entrepreneurs, to comply with the same requirements as big tech companies, then guess what's going to happen? These companies, they won't be able to make it. And so, it's gonna have a big impact on technology. And that's why I think we've seen, for example, in the UK, the FCA, the sandbox. And the sandbox, some people may argue against it, some people may argue, for it. But the sandbox also is a good idea, because you're allowing these startups basically to test their products or services in a closed environment. And then once you're confident, you as a regulator, once you're confident that they're, able to go out to the public, and this is where you're gonna license them. You're gonna give them the final license or the approval, and then they can start working. But until then, you as a regulator, you want to have oversight of their technology, and also from an entrepreneur or from a startup perspective, you want to give them the ability to test the product or service, because it may be that the product they're looking at could be, for example, like an AI product or a blockchain, use case, or whatever they're doing. It could be that they will change this over time. So then requiring them to comply with high standards doesn't make sense, right? There is no one size fits all. And so this leads to probably one of the biggest questions is that how you regulate code, because we're talking about like the cyberspace. And so the code, you can change the code in a second. So for example, you've got like these cookies, not the cookies that you eat, but the cookies on for example, on the browser. And these cookies, they record everything. So, you're on Amazon, for example, you're browsing, I don't know, you're looking for a book, and then you close the Amazon browser, and now you're on your Gmail, and suddenly you get ad, with similar books. And this is all because you've got these technology, these cookies. Now, from a technology perspective, you can change these cookies in seconds, right? The way you program it, the way you structure it. But the question, in order for a regulator to come up with the proper regulations, in relation to these cookies, well, the process is going to take 6 months, a year, maybe 2 years. So once you have this, look, best example is the GDPR. I don't know how long it took the European Commission, looking at signing at the GDPR, but now you've got like these new technologies that are not captured under the GDPR. And so the question is that how do you regulate these new technologies? And I personally think, we should be looking at this from a different perspective. Could be regulating by code. There are some people who argue for regulating by code. So, privacy by design, maybe, and which is, again, I think for the past few years, it's been getting lots of attention, especially in Silicon Valley, and similar tech hubs. But this is, I think it's a big question. How you regulate innovation and law and innovation. Do they get well along together or not?
I think the interesting way to tackle this that I've not seen a huge amount of engagement of is education. So educating people about their data, educating people about the value of their creativity and their input is exceptionally important. As we move more into an automated world where our value is our intellectual capital. So, I mean, I read a book, dating me now, a book called Future Wealth, which is, I think is still in publication under the Harvard Business Review, back in the 90s, in the late 90s when I was a student. And it's when I reread that book, when I was thinking about this panel, it was something that stayed with me, where they pictured a world where we had this internet and we were connected. And in it, they did various bizarre business scenarios where you were thinking about AI making decisions for people, and all that. Nearly all of those things have come true in that book. It's a fascinating read, and I'd highly recommend it. But it talks about, actually, if you think about what intellectual capital is worth, and you try to think about how you would value the graduate class of Harvard in 2020, Harvard Business School, and what the intellectual capital of that class will do in society, I think that's where we're going to see trends. So I think educating people about the value of their outputs and inputs into society is going to be something that's going to be quite interesting.
I agree, but that also goes to data protection, some of the principles of transparency and Article 13, and telling people how you're using the data, how your technology works, taking someone through it, and actually just being very open to people so they really understand, and it's written in language or shown through pictures, something which they can understand. And I definitely think that's a trend, and certainly the way forward.
I think for the students that are online or participating, or early practitioners, I would advocate always going and look at what the Stanford Law Lab are doing in this space, with the work and the input from IDEO and Rochelle and her team at IDEO and the legal design service there, and thinking about actually how you explain privacy terms in a different way, or when you look at in Australia what they've done with pictorial contracts, or the Future Law Innovation Program in Singapore. They've done kind of schemes of work around this to think about how you communicate in a different way and educate in a different way, because I think that's going to be really, really important. And definitely when we think about some of the themes we've talked about today about explainability of AI and financial services as well, because that's going to be really important, thinking about, actually, you've looked at me with an algorithm for my creditworthiness. What is my value to you as a bank? You've decided and you've made decisions all on these data sets. But actually, if I choose to manage my data in a certain way, can I play a game with those people? What can I do? What can I achieve?
Absolutely. And I think as well for students, that going back to that point as well about the education, is also talking, as you start to become more your junior practitioner, about how your clients want their work delivered, and not assuming they just want this like lengthy memo or something, exactly. And so, and some people as well, like if you talk to someone and they actually say, well, actually, you know what, I'm dyslexic, or I find it really hard to read things, actually be like, okay, well, I could do something in pictorial form, or really trying to get some of the concepts across in different ways. And I do think clients really appreciate that too.
It's so true. I mean, for me, when I was dealing with my innovation office and the innovators inside the bank, it was quite often I could have written a beautiful piece of work on why they should care about NDAs and why all of the team should try and get an NDA in place before they talk about all these amazing things that they're trying to build and do. But actually, it was me recording a 2-minute tops video of why they should do them. And then making sure that there was always, in various ways, a loop back system, so they had the pop-up before they put the meeting request in to go and get them to have the NDA in place. Creating habit, creating a different way of people remembering and reminding them to work, that's what did it. That's what got the NDA rate up. That's what made sure they were actually putting a description in the NDA that I had any chance of ever litigating off, rather than we're going to randomly talk about some things. That this was the type of thing that I was dealing with in-house. So making sure that in private practice, it isn't just about as a practitioner telling me everything you know about a subject and then sending me a beautiful document. It's actually, how are we going to get these people to change their habits, do the practical things to give them the tools that they need? So with that in mind, we talked a little bit about counterfeit and IP. What do we think we could do and how we could leverage AI to given that 70% of all counterfeit goods are sold online, do we think we need to be putting more on the platforms? Do we think we need to be thinking about what their obligations are? I mean, now we've got better takedown services, but do you think that's something we need to think about in our practice? And do we see that changing anytime soon?
Yeah, well, I'm happy to take that one. I mean, I think with platforms, you know, technology lawyers for some time have been predicting that there's going to be greater regulation of the online platforms, and not just in relation to counterfeit products, but I think particularly in the current climate, you know, with disinformation about COVID-19, you know, we have a lot of fake news on these platforms. We have a lot of hate speech on these platforms. I think there's a real onus on the platforms to do more. And certainly the European Commission, I think, is already aware of that and is already taking steps, because they've introduced a new digital services package, which was launched a couple of weeks ago and which is currently in the consultation stage. And certainly that package looks at whether these platforms should be doing more and whether there should be greater responsibility on these platforms to monitor the content on their platforms, first of all. And given the size of these platforms, I think it's inevitable that they'll have to use some form of AI or some kind of content filters in order to manage that. But then how do they make sure that it stays down? And how do you block repeat offenders? You know, people can create new accounts and start posting the same sort of content or start selling counterfeit products if they wanted to. But we need to have more sophisticated systems in place to be able to deal with that. And yeah, that responsibility falls on the platforms because they're best placed to do it. I also think the other thing that's interesting is getting platforms to cooperate with each other, because actually you often have serial offenders across platforms, and you know, devising some form of common standard that requires all of the platforms to kind of, you know, police the content to the same level would mean that we might get some consistency across the platforms as well. But, you know, that's a big regulation. That's going to be a big task. I suspect that a lot of the platforms will counter some of the proposals that the European Commission has made, because from the platform's perspective, it then puts a huge burden on them to monitor and police everything on their platforms. But we need to find a balance somewhere. So I think that's going to be a hot topic for some time. And sorry, Raka, I think you were about to answer that question too.
No, that was actually very, very informative, Priya. And in fact, just to complement to what you added, since you generally added onto the platform issue, I kind of came across a couple of examples where I believe that would kind of complement onto the information which you made. That apparently Amazon definitely is working very strongly on this, as obviously being a very popular online platform in any case, being a marketplace where they definitely need to be more responsible, given that they have been battling on fake products for a very long time. So in terms of the kind of blending of, so it's interesting to see how machine learning and real as in human programming engineers and research scientists have kind of blended together, where here we see kind of a blended approach of human and AI working together towards the brand registry program which Amazon has. And they claim to be almost cutting down on encroachments by 99% towards that. Amazon had also divulged with Project Zero, where they're looking at a complete no human intervention process to be set up, where the entire fake brands will be looked into and automatically taken off. So I think in terms of looking at online platforms, these are the kind of like a real-time example kind of mention that these are the kind of steps or initiatives which would be required and which I'm sure would be getting more and more evolved and developed in the coming times with the more number of counterfeits that they would be facing and kind of taking a step on. So in my mind, I believe, I mean, there's this question I generally, I mean, because it's a very interesting panel where we do have so many experts kind of thinking together. I'm just taking a liberty, Victoria, to just pose this question to the panel that while we all have been wanting to have been seeing that there is always a battle between, especially if it is IP, there is a battle between human and artificial intelligence and who prevails where. So what in your mind would be the one, kind of, I would say the message that is underlying in all your minds that as of now prevails so far as the present laws and the present AI status is concerned?
So who wants to go first? Because we've got a few minutes to quickly answer. I don't know if you want to have a go, Anne, or...
Well, I assumed it was a rhetorical question. But perhaps, Raka, you can tell us what your view is from the Middle East on that one. I mean, I think it's quite an interesting debate to work out where the balance lies between humans and AI.
Well, in so far as what we see, what Paul already kind of hinted and mentioned about UAE and Middle East being that way quite progressive in terms of being, taking certain government steps towards having embraced AI in all its oddities and positives. Well, if I have to give a one-line answer to it, I would say, well, it definitely still remains to be a blended status where it's both, human and AI, which is going hand in hand. It is a matter of time to see whether it is going to be the AI power which literally takes over, or it still remains sourced to the human thought processes to operate AI in a particular level.
I mean, I think we're in a place where we've got quite a while before we have to worry about that, thankfully. But I think ultimately we're in a phase where this complements us, this helps us. And as long as we design the right frameworks around how we leverage these technologies, then I think that these are tools that enable us to get to that utopia where this is the Jetson world that we want to live in, and we can have in science fiction. So yeah.
Yeah, I would agree with that. And I think for me at the moment, I don't think we're at a stage where we see real artificial intelligence. No. I mean, we have some machine learning, we have some, deep learning algorithms as well. And it's very much about augmented intelligence is a phrase that I've heard others use. So, as Rob was saying, as a lawyer, it's about augmenting my experience at work. It's about using tools to take away some of the automated tasks and to take away some of the rote tasks, and allowing me to do some of the really interesting things. So I think that's sort of where we're at. The robots haven't taken over just yet.
But I do feel that, I mean, I'm a big fan of Stephen Hawking, and in his posthumous writings that were published probably just over a year ago now, actually, in his final chapter of his book, he talked about getting things right. And as somebody who had worked very closely with Intel about developing neural network and the technologies that they've always been looking at in this space, I think it is important that we work collaboratively globally to think about these tools and technologies that we are building, and that we do strive towards developing fair, ethical principles and frameworks, and that we do remember that in these product development journeys, we need diversity, we need to be inclusive. Otherwise, we will be repeating the same mistakes that we have for a very long time. That's why there wasn't a female astronaut suit, because they didn't assume there would be any female astronauts. So that delayed that project being developed slightly. Just like women have issues with heart medication, because most of the high blood pressure medication is tested on men, not on women, because they assume that this is something that will be impacted by lifestyle choices. So when we're developing algorithms, and as we saw in the lovely example we had in financial services of how women were treated differently when products came out recently by certain global banks, we need to think about that. So I would urge everybody to get engaged in this space and learn about it, and take the time to understand what you're doing with your data and how your intellectual capital is going to contribute. And I would like to thank everybody on the panel. I've learned a lot from it, and I hope those listening have as well. There will be a recording and some follow-up information from the panel. So I'd like to thank you all for being part of this, your time and your thoughts. And I'll hand back to Jasmine to provide any closing remarks.
Thanks, Victoria. Thank you once again to our panelists for sharing their thoughts on this topic. Thanks, Victoria, for moderating. And thanks to our attendees. I mean, this brings us to the last of our legal tech webinars for this 3 days. I think they've been great, and it's been wonderful to see some attendees who we've seen consistently across all 6. I'm afraid if you're not one of those who are able to attend all of them, but you still wish to, there will be recordings given out in due course, so do keep an eye out for those. But I think that leaves us with the end of our webinar. So thank you very much again to Victoria for moderating this panel, and all of our panelists, and again our attendees. So bye guys.
Bye, thank you.